Test. Palais Wilson, ground floor, webcast. Est-ce que c'est bon? Alors, on fait le test en anglais, canal anglais, le 2.
Good morning. I'd like to welcome you to the meeting of number 4245 of the Human Rights Committee. This is a public meeting and on webcast. It is devoted to the continuation of the consideration of fourth periodic report of Vietnam. Your Excellency, Mr. Nguyen Thanh Tin, you have 15 minutes to continue with your outstanding replies yesterday. Thereafter, I will give the floor to a number of the committee members to pose their questions on the second half of list of issues, which are issues 14 to 26. And as yesterday, your delegation will then have a 15-minute break to allow you to prepare your response to the questions posed by the members. You will then have 1 hour to respond to the questions posed, after which we will have time for follow-up questions and answers. The meeting will adjourn at 1 p.m. today. So without further ado, I would like to give the floor to Your Excellency, Mr. Nguyen. Excellency, you have the floor.
Thank you, Mr. Chair. Good morning, everyone. So for the meeting yesterday, Vietnamese delegation received a lot of questions from members of the committee, and also we provide our responses to the question raised by the members of the committee regarding to the first 13 questions raised by the committee regarding to those issues in LOI. And with the approval from the Mr. Chairman and also members of the committee, now I would like to invite members from my delegation to provide additional information. Mr. Chair, distinguished member of the committee. So within 15 minutes, we are going to provide 4 main groups of responses. First, I would like to invite representative from Ministry of Public Security to take the floor first. Good morning, Mr. Chair and members of the committee. Regarding to the question of detention, I would like to share the following additional information. Firstly, would like to confirm that Vietnam does not use the measure of transfer prisoner away from their residential address as a punitive measure. The decision on the location of the prison is made based on a lot of different factors. For example, the number of prisons available in each location. And we follow the principle of allowing the prisoner to stay closer to their family members so that it can facilitate family visit for them. We also encourage them to better perform while they are kept in the prison. And also the second reason, for example, we have a different category of prisoner. For example, pregnant women, foreigner, and also juvenile, for example. And also we consider the situation of each prison. Let's say that if the prisoner, are kept in a certain prison close to their family residential address, but due to the capacity of the prison, it could not be feasible. And also, as I mentioned earlier, it depends on the type of offenses. For example, for very dangerous criminal cases or extremely dangerous criminal cases, we will not give the same members of criminal network at the same prison for the reason of security. Vietnam is striving and making great efforts in order to ensure better conditions for prisoners. And now we are amending the criminal judgment execution law and also the law on custody and detention so that we can better ensure more favorable conditions for prisoners. And also we make the best use of information technology so that we can have smart prison administration and governance so that we can prevent any potential violation of human rights against a prisoner. Regarding to the next issue, compulsory rehabilitation at drug center according to the Drug Prevention and Control Law of Vietnam, only certain people will be subject to compulsory detoxification and rehabilitation treatment. Firstly, they are not volunteer to participate in such a program, and secondly, they are recognized as a drug addictor, and also they refuse to use the medicine, used in drug treatment, drug detoxification treatment. So if they fall under those category, they will be subject to compulsory rehabilitation center. And such a decision must be made by the local authority and must be reviewed by the court of the same level before the decision is valid and before they are introduced to the compulsory rehabilitation center. They must be screened under 5 phases. Firstly, identification of drug addict, and so second phase, assessment on their situation, and also they will be subject to labor therapy treatment. At compulsory rehabilitation center, there's no case of forced labor, but they perform labor therapy. Labor therapy aimed at assisting them to building more skill and also to help them to, get better with the treatment, and they can take care of themselves. And also, for example, they take care of their health and they can cook for themselves and they can do farming activity, and also they also are allowed to enjoy sport activity as well as other cultural activities. For farming activity, the product produced by those people will be used as the food to be served at the center. It means that such a product will not be sold on the market for the benefit of anyone else. Now we have a 97 rehabilitation center established by the state with a capacity of hosting 60,000 persons. In 2004, we successfully provide treatment for more than 80,000 persons. And now we also are providing such, treatment for a lot of persons at different age. Of course, including both voluntary and compulsory rehabilitation service. Of course, we know that we should encourage voluntary treatment service, but only when such a voluntary treatment service is not successful, we will move to the compulsory treatment service. For those under 18 years old, we, have the policy to move them to the reformatory school where they can be provided more educational opportunities so that they can continue their education career, and also they have a better way forward after they leave the reformatory school. So, Mr. Chair and distinguished member of the committee, I would like now to clarify the question regarding to the climate change response, particularly for vulnerable groups. Climate change response is one of the top priority when we develop our strategy and policy for sustainable development. We have hundreds of NGO and social civil organizations actively working in this sector. For example, they participate in law drafting process and also provide input for policy development process in Vietnam, and also they participate in the oversight activity and monitoring activity. And also in Vietnam, we have a number of pilot projects in order to better respond to climate change, where we have engagement from the local level to the central level. And also we implement a lot of communication campaign, particularly communication campaign for the ethnic minority and mountainous areas, so they can benefit more from those activities in the process of making law. For example, national strategy on climate change, and also action plan on climate change, and also in the process of drafting a number of reports to the UN on also the NDC report. Vietnam hosts a wide range of consultation, workshop, and events to collect input from NGO, civil social organization, different professional association, for example, Vietnam Association of Technical Organization, Farmer Association, Women Association, and also the NGO Working Group on Climate Change, just to name a few, and also the Network of Youth for Climate Change Resilience, for example. Those input from those partners are carefully considered by Vietnamese authority when we prepare our report and develop our policy and strategy. One example, the program of 1 million hectare of rice that we introduced yesterday. This program is implemented in the Mekong Delta in the south of Vietnam, where we have a lot of different ethnic groups. The King ethnic group account for 92%, Khmer 6%, and other ethnic groups. And altogether, we have 44 different ethnic groups in those areas. That is also a very important area for agriculture production in Vietnam. At the same time, this area is prone to climate change. So the program of 1,000 hectares of rice implemented since 2023. And actually, the pilot program was started in 2015 so that we can move to more sustainable cultivation methodology compared to the convention methodology used by farmers in the past. So during the pilot phase, the rice production efficiency increased 30%, and also we reduced 8 tons of gas emission per year. So with 184,000 hectares of rice and also more than 160,000 farmers participated in this program. So under this program, the working hour of farmer reduced, significantly. And this area is the place concentrate a lot of ethnic minority group as well as the ethnic women. So we can see the working efficiency increased. Meanwhile, the working hour decreased, so that the livelihood of the people has been improved significantly. So with this project, we can see the important role of the direct participation of the women, of the ethnic minority, of the local community as a whole, working with the state authority in order to bring about the success of this program. In the next few years, in the time to come, we will continue to pay more focus on public consultation and capacity building activity. For example, from now to 2030, we will have supporting activity to more than 800,000 participants, including the training for ethnic minority in different language. For example, Khmer language. We have 4 more minutes. So yesterday, Mr. Zikazu put one question regarding to the institution in Vietnam, regarding to human rights institution. The available mechanism now in Vietnam is equivalent to international human rights institution worldwide. So that is a good, ground and basic for the development of a separate human rights institution of Vietnam. That will be the single institution, but will not replace the current available mechanism, and there will be no duplication and overlapping in the function of those agencies. So the establishment of such an institution requires the amendment of the law in Vietnam, including the constitution. Therefore, it is a time-consuming process. The People's Advocacy Committee is a quite independent committee in Vietnam, and now we are implementing resolution number 27 on the development of socialist rule of law state in Vietnam, where we devote a lot of effort in the promotion of human rights. So in particular, Vietnam is paying more attention to streamlining the governmental structure, and we are now having the 2-tier governmental structures. Therefore, the establishment of national institution on human rights must be very carefully considered. We just need more time to consider thoroughly. And talking about independence of such an institution, Paris Agreement is a persuasive authority, not a binding authority. But in the time to come, we will carefully consider Paris principle so that we can better facilitate the establishment of this institution. We highly appreciate your question, Mr. Jicharu, but we would kindly request you to consider carefully the context, the situation in Vietnam, to recognize our effort in, the promotion and safeguarding of human rights in general in Vietnam. So regarding to the question on corruption crime, we have a mechanism in Vietnam available to detect corruption, for example, thanks to inspection mechanism, oversight mechanism, or receiving report and denunciation from the people and the community as well. And similar with other criminal cases, for corruption cases, we also need to go through different procedures according to the data available in Vietnam regarding to the corruption cases related to high-ranking officer, for example, judge, prosecutor, investigator. From 2019 up to date, we receive investigate on 321 cases involving more than 500 defendants, in corruption cases related to high-ranking officer. So that's all for Vietnamese delegation, and we would like now to give floor back to Mr. Chair and members of the committee. Thank you.
Thank you very much for your replies. It seems to me there are still some questions unanswered today, but after we have a second round of questions, maybe later this morning, you may have some time for reply. So I hope we can get the replies. And also, if you cannot, you have 48 hours for your written replies after the end of the dialogue. So I will begin the second round of questions. I'll start with Mr. Igeju. I give you the floor.
I thank you, Chair, and I wish a very good morning to the delegation. My questions for this morning will be on paragraphs 14 and 15 of the list of issues. So going to my question on paragraph 14, the committee notes the information provided by the state party that all fundamental legal safeguards are provided by law, including prompt access to legal counsel and family members, as well as legal guarantees that ensure that there is no prolonged detention without trial and that accountability mechanisms has been put in place for violating such legal safeguards. However, Article 173, subparagraph 5 of the State Party's Criminal Procedure Code provides that government prosecutors can hold suspects accused of national security crimes in detention for an unlimited period of time without trial or judicial review. And Article 74 allows prosecutors to restrict access to legal counsel in cases related to suspects accused of national security crimes until the conclusion of the investigation and with no time limits. Such individuals may also not be allowed to meet family members. Such provisions appear to be contrary to international human rights standards, as well as the right to a fair trial as provided under the relevant provisions of Article 9 and 14 of the Covenant. I wish to note here that between 2017 to 2023, the Working Group on Arbitrary Detention adopted 27 opinions on claims of arbitrary detention against Vietnam. The Working Group on Arbitrary Detention noted that denial or restricted communication with family members, lack of access to legal counsel, denial of medical treatment and medication, restrictions on freedom of religion and belief in Vietnam were among the human rights violations experienced by those arbitrarily deprived of their liberty, according to the Working Group on Arbitrary Detention. Can the State Party therefore please provide information on concrete measures it will take to consider revising or repealing Articles 74 and 173 of the Criminal Procedure Code and other provisions that are not in line with the obligations of the State Party to the Covenant, and cease in practice the use of extended pretrial detention without judicial oversight, and ensure that all detention is subject to review by an independent court, ensure that any deprivation of liberty is lawful and that detained persons are afforded legal safeguards from the outset of their detention, including immediate and regular access to legal counsel throughout their pretrial detention, as well as ensuring lawyer-defendant confidentiality, ensure that pretrial detention is used only as a measure of last resort and for the shortest period, following a proper individualized assessment and for reasons expressly provided by law and in line with international human rights standards and the Covenant. Going to my questions on paragraph 15, the state party has provided detailed information on several policy and legal measures taken to prevent and combat forced labor and human trafficking, which is well noted and appreciated. However, reports before the committee indicate that trafficking in persons continues to be a serious concern, with domestic trafficking accounting to 45% in 2022. Key concerns that are raised in reports are that 16 and 17-year-old children are still dealt with in the same manner as persons above 18 years of age, requiring demonstration of means to constitute a trafficking crime. The lack of a clear framework for the protection of non-Vietnamese nationals trafficked to Vietnam or transited through Vietnam to a third country is also noted as a concern. There are no substantive changes in government policies and efforts to combat labor trafficking in state-run labor export program, which reportedly is far more severe than other privatized forms of human trafficking. Reports also show that the number of shelters are still limited and does not cover all regions. Financial and specialized human resources are insufficient, particularly specialists who provide psychological support and long-term rehabilitation of victims. There is a lack of long-term mechanism to support foreign victims, particularly in regard to provisions of residence, safe repatriation or smooth living condition in Vietnam if they cannot return to their home countries. Can the state party therefore please provide further information on measures it plans to take to revise anti-trafficking laws and the criminal code to ensure their compliance with international standards and to extend full protection for victims aged 16 to 18, strengthen international legal cooperation and national law enforcement capacities to investigate and respond to the linkages between cybercrime, human trafficking, and migrant smuggling, strengthen international cooperation to ensure cross-border access to supporting services, especially with countries that have many victims or unsafe migration flows, encourage and support social organizations to operate shelters with high standards. This ends my question for this morning, and I thank you for your attention. Thank you.
Thank you, Mr. Geju. Now I'll give the floor to Madam Basim.
Thank you, Mr. Chairperson, and good morning to the delegation and to all who are present here. My first question will be on freedom of movement. With reference to paragraphs 66 and 67 regarding the freedom of movement of Vietnamese citizens provided for in the 2013 Constitution and set out in various specific pieces of legislation, the cases where travel restrictions are imposed by law, taking into account the replies of the state party, paragraphs 53, 55, and in view of the concluding observation of this committee at the end of the third review of Vietnam in 2019, the committee welcomes the passing by the National Assembly in its 15th session of the law amending and supplementing a number of articles of the law on exit and entry of Vietnamese citizens. It notes with satisfaction the introduction of new provisions to facilitate administrative procedures related to passports and exit and entry processes for citizens, including electronic submission of applications for ordinary passports. Nevertheless, the committee remains concerned about the directives on international travel that closely manage officials, party members, and Vietnamese citizens that go abroad to do business, cooperate, engage in exchange, visit, or travel. It is also concerned by the fact that the law allows authorities to postpone the departure of any person on various broad grounds, including for national security and defense. It's noted that Article 121 of the Criminal Code criminalizes all persons fleeing abroad or defecting with view to opposing the people's administration. Thus, it is in contradiction with the Constitution. Many reports have shown cases of persons being prevented from leaving Vietnam to seek asylum, including members of ethnic and religious minorities and indigenous people. Some of these cases were subject of a joint allegation letter issued by the special procedures of the UN Human Rights Council in April 2020 and April 2023. It is also reported by reliable sources that the authorities of Vietnam routinely violate the right of freedom of movement and other basic rights by subjecting religious and other activists, dissidents, human rights defenders to indefinite house arrest, detention, surveillance, international travel bans, confiscation of or refusal to issue passports, as well as different forms of detention. In this respect, please provide information on new measures taken to guarantee freedom of movement, ensuring that any restriction imposed is compatible with the Covenant and its General Comment number 27. Please enumerate the criteria and legal grounds applied for decision to restrict or ban international travel on Vietnamese citizens and whether any appeal process is available. Can you provide statistics on the travel bans issued during the reporting period and how did the authorities deal with them? Please comment on reports asserting that members of ethnic and religious minorities and indigenous people have been prevented from leaving Vietnam and that human rights defenders, religious activists are routinely subject to discriminatory restrictions on their freedom of movement. Now I will turn to the legal protection for children 16 and 17 years old. With reference to the committee previous concluding observations, paragraph 38, as well as the country reports on the implementation of the CRC and the national report before the UPR cycle on human rights, as well as the fourth periodic report submitted to this committee by Vietnam, paragraphs 112 and 13. The committee takes note with appreciation of the significant progress that has been made in juvenile justice thanks to an increased awareness of the importance of legal institutional reforms. However, these improvements are neither systematic or comprehensive, and detention of children in conflict with law is still common. Children still face obstacles in accessing fair and timely effective remedy. These obstacles are weak coordination, lack of strategic planning, limited capacities, lack of community-based services, limited awareness, and support from the public and community. The law on children defines the child as a person under 16. years, while the age of majority is set at 18 years of age by law, which creates a significant protection gap for children 16 and 17 years, especially those who are victims of child abuse, sexual exploitation, trafficking, deprivation of liberty. Can you please describe the progress made in amending the legislation to address the protection gaps for children aged 16 and 17 years? Measures taken to strengthen the juvenile justice system by setting up additional specialized courts with trained judges, improving community-based services, and ensuring children are not deprived of liberty and alternatives to detention. Steps taken to ensure that measures such as detention and incarceration are only used as a last resort for the shortest time for the shortest period of time. Can you please provide statistical data on the number of children under the age of 18 deprived of their liberty in terms of numbers, duration, and reason for their detention? Can you please provide more information on the progress achieved as far as the proposed law on juvenile justice and the impact of training provided to officials in the juvenile justice sector? Finally, going to right of privacy and all reported allegations concerning the misuse of the All People Protect National Security movement, especially in residential communities, industrial parks, economic zones, export processing zones, and areas with a large concentration of workers. On the other hand, the decree number 13 of 2023 on the protection of personal data categorizes the latter as basic and sensitive. Basic personal data includes nationality, ethnicity, data that reflects activities and activity history in cyberspace, while sensitive personal data includes political and religious opinions, sexual orientation, gender identity. However, Article 17 of the decree lists exceptions when personal data can be processed without prior notification and consent of the data subject, such as cases concerning national security, prevention of terrorism, crimes, and law violations. Can you please comment on allegations of targeted surveillance arbitrarily conducted on political activists, journalists, and human rights defenders, including through the use of technology, such as the Predator spyware, through censoring, opening, and confiscating private mail, the interruption of phone and internet services without legal warrants? Can the delegation please provide information on decree number 13, 2023, with regard to Article 17 of the decree, providing for exceptions for the respect of the right to privacy? Can you provide statistics on the number of complaints alleging violations of the right to privacy and information on the legal basis and outcomes of the investigations conducted, the sanctions imposed, and any remedies provided to the victims? Thank you.
Thank you very much, Madam Basim. I will give the floor to Mr. Ndiaye.
Thank you very much, Chair. Once again, I wish to bid a warm welcome to the delegation from Vietnam and to all other participants in the room. I hope that the night brought good counsel and did so with fresher temperatures than usual. Now, I want to deal with list of issues numbers 17 and 20, judicial independence and participation in public affairs. Now, your answers provide new regulations and draft proposals to improve judicial independence and to prevent undue influence. However, you do not provide any specific examples or evidence of reduced political influence, particularly from the ruling party, over the judiciary and the prosecution service. Could you please provide specific examples of how the new laws and regulations, such as Regulation number 132 QDTW and the 2024 revised law on people's courts, how these have effectively reduced political or party influence over judicial appointments, decision-making, and the operations of the judiciary and the procuracy in practice? Now, you mention improvements in due process and increased legal aid, but your reply does not address how these guarantees are assured in cases involving journalists, human rights defenders, political activists, or persons accused of national security offences. Can you tell us what specific measures have been put in place to guarantee the presumption of influence, access to a lawyer of one's choice, and a trial within a reasonable time? Could you please provide examples on how these safeguards have been applied in such cases? Now, you say that lawyers are provided with support and are protected in the exercise of their functions, but you don't address the committee's concerns about threats, intimidation, or legal proceedings against lawyers that are representing sensitive cases, such as human rights defenders, political activists, religious leaders, or national security cases. Can you tell us what specific steps you've taken to prevent and punish threats, intimidation, or harassment, including legal proceedings, against lawyers for their work on sensitive cases? Could you please provide information on any disciplinary action taken during this reporting period? I now come on to judicial oversight and accountability. Now, your reply mentions draft proposals to establish judicial oversight over legislative and executive agencies, but you don't tell us whether such mechanisms are already in place or whether they're effective. Have any independent mechanisms for judicial oversight ever been established or implemented? And if so, how do they function in practice to protect judicial independence and to ensure accountability? Can you provide data on the number of lawyers and legal aid cases? I mean, you do provide some of this data, but you don't disaggregate this data by case type, etc. Can you please provide disaggregated data on legal aid and on the outcomes of cases involving journalists, defenders, activists, and those accused of national security offences? I now come to the issue of participation in public affairs. Now, in your replies, you state that the people's choice of the political system fully complies with the ICCPR and that active and proactive participation in political, economic, and social life is a constitutional right. But you do not specify any measures taken to encourage and promote pluralism. What measures have been taken to encourage and promote pluralism as requested by the committee? You state that there are no legal requirements for candidacy or elections to be subject to the conditions of the Fatherland Front or the approval of the Communist Party, and that many candidates are not party members. This is in paragraph 89, but you don't express the process for candidate approval or selection. Can you clarify the process and confirm whether any conditions related to the Fatherland Front or political affiliation apply in practice? You mentioned that voters cast their votes in person and that election and candidacy activities are monitored and supervised, but you don't tell us what steps have been taken to establish an independent monitoring body. What steps have been taken to eliminate proxy voting in practice? And has an independent electoral monitoring body been established? You also state that Vietnam does not detain or penalize political dissidents, but you do not comment on the committee's reference to reports of arrest and detention of political opponents, including at least 3 independent candidates before the 2021 election. How do you respond to reports indicating the arrest and detention by police of political opponents, including at least 3 independent candidates ahead of the 2021 National Assembly elections? And finally, your reply doesn't address the committee's request about steps taken to revise legislation denying convicted prisoners the right to vote. Have you taken any steps to review legislation denying convicted prisoners the right to vote? Many thanks for your attention, and I await your answers with interest. Thank you again.
Thank you very much, Mr. NDIA. Now I'll give the floor to Mr. Hernandez Lieja.
Thank you. Buenos días, President.
A very good morning, Chair. I now want to refer to paragraphs 23, 25, and 26 on right of peaceful assembly and freedom of association and the rights of minorities and indigenous peoples. Now, Decree 126 of 2024 on associations has been presented as a positive measure, but the information reaching the committee are worrying, and they relate to the fact that this could be some backsliding comparing to Decree 45. There are also decrees that grant the government powers to supervise, suspend, and dissolve associations without sufficient procedural safeguards. Now, this discretionary administrative power has been used to hinder or eliminate organizations deemed non-aligned with state objectives, in particular, some dedicated to environmental advocacy, anti-corruption, or minority rights. We've also had reports of repression of religious minorities. The committee recalls that the right to peaceful assembly is not just limited to the political sphere. It also protects the rights of the faithful to assemble for spiritual purposes. We are particularly concerned at the conviction of Yikrek Bia, a member of an unaffiliated evangelical church, to 13 years imprisonment with an additional 5 years of house arrest for undermining the unity of the church. We also see with concern the prior authorization regime for the establishment of associations rather than a notification system. This gives an excessive margin of discretion to the authorities, and there are no independent judicial mechanisms to ensure an effective review of negative decisions. Now, this is a restriction which can have a negative effect on freedom of association. What measures has Vietnam taken to ensure that the right of association can be exercised without interference? The committee also notes with concern the growing number of administrative rules which restrict associations' access to financial resources, especially those that come from foreign sources. There's also a lack of real autonomy of the 93,000 associations that are restricted, that are registered. There are various decrees, 80/2020, 56/2020, and 6/2020, impose obligations of notification and prior authorization and even political control over funds, particularly in areas considered sensitive. These include human rights, religion, or national sovereignty. In the committee's views, access to financing is a component of freedom of association, as is said in General Comment 37 of the committee, and particularly paragraph 62. The restrictions that are currently in place appear to go beyond what is necessary in order to achieve legitimate aims in a democratic society. Can the delegation provide detailed information on rules applicable to associations that receive foreign funding and on the differences in legal treatment between national associations, foreign associations, and those receiving international funding? How does a state party ensure that this is compatible with the freedom of association? In recent years, activists have also been detained, imprisoned, sentenced, accused of tax evasion. The criminalization of social leaders because of supposed tax infractions in a context where tax laws are vague is a difficulty. This also creates a climate of fear within associations. There is the question of extraterritorial dimension of restrictions of human rights defenders, such as arrest warrants against activists that are in exile, particularly against Mr. Wen Ti-kyo Vien, the founder of Towards Transparency, the only anti-corruption NGO that was at that time operational in Vietnam. Now, paragraphs 25 and 26 now, relating to the rights of minorities and indigenous peoples of Vietnam. Now, the Constitution says that national unity is based on equality between all ethnic groups. Now, there have been various programs adopted for the development of ethnic minorities and mountainous areas. There has been improvements relating to poverty, access to electricity, water, sanitation, education, minority languages, as indeed you point out in your reports. However, the real legal situation of indigenous rights and minorities is of concern to the committee for a number of reasons. There's no differentiation between indigenous rights and minority rights, for example. Can you please let us how many minority groups and indigenous groups are recognized in Vietnam? We're particularly concerned at the situation of the Khmer Krom and other indigenous groups which don't seem to be recognized as such. We're also concerned at the lack of protection for cultural rights because of certain resolutions such as 24 NQTW of the Communist Party of Vietnam, which says that there must be the eradication of obsolete customs and practices in favor of national unity and harmony of the bloc. We've also had concerning reports of arrest, torture, and unfair trials of indigenous, religious, and cultural leaders from indigenous groups, as well as restrictions on some religious minorities that have been compelled to integrate into state religious structures. This is particularly true of the Montagnards and the Protestant Christian religious minorities. The committee would particularly like to know whether Vietnam guarantees compliance with Article 27 of and 1 and other provisions relating to the right to identity, to learn a mother tongue, culture, religion of minorities, and the right to self-development, the right to be consulted on decisions that affect them, and rights connected to the territories. These are all rights enshrined in international law. Are these recognized in Vietnam? And there have been very many cases of persistent discrimination of minority groups and indigenous groups. What measures does Vietnam taken to eradicate systematic discrimination against these communities relating to employment, education, or public services? Now, there has been some progress on language, minority language teaching, but could you please provide more information? We would be very grateful. The committee is also concerned about the situation in boarding and half-boarding schools for indigenous children and whether they have the right to learn and practice their language and their culture. The committee has also received alarming reports on limited access and ownership possibilities of ethnic minorities, despite the land law that has been promulgated. Could the state explain the mechanisms used for consultation of indigenous groups before tourist, agro-industrial or forestry projects are carried out in their traditional lands? And to what extent is there fair and adequate compensation in case they are stripped of their land? Thank you.
Thank you very much, Mr. Fernandez-Lieja. I'll give the floor to Mr. Terrea.
Thank you, Chairperson. Good morning. I hope the delegation of Vietnam had a restful night. This morning, I will raise three issues, issue 20, 21, and 22. Issue 20 pertains to freedom of conscience and religious belief. In its reply, the State Party notes that the new 2023 decree was adopted to ensure better protection of freedom of belief and religious and aligns fully with Article 18 of the Covenant, and that it replaced the earlier 2017 decree for this purpose. The committee has taken note of the certain provisions of the 2020 concerns. These include provisions granting broad powers to central and provisional authorities to suspend religious activities and requirements for prior authorization for religious training, charitable donations, and online religious activities. The committee would like to ask, in what ways do these provisions contribute not only to better protecting freedom of religion or belief, but also to ensuring compatibility with Article 18 of the Covenant? One of the key points, key issue concerns the registration of religious organizations. While the State Party notes that all religions are equal before the law, it appears that the term all religions refer primarily to registered religious groups. The State Party also states that the recognition of religious organizations is carried out pursuant to Article 19 and 22 of the Law of the Belief and Religion, and reasons are provided in cases of denial. First, what is the procedure for registration or recognition? How long does the process typically take from initiation to decision? Does it allow the applicant an opportunity to respond or appeal during the review process? Second, what are the reasons for denying registration to certain organizations? In particular, how does the State Party justify the non-registration of relatively large religious groups such as Cao Dai and Hoa Hao? The committee would also like to raise some specific issues. According to the information received, members of the unregistered Montagnard and Hmong Protestant groups have reportedly been subjected to harassment by local authorities in various provinces, particularly in the Central and Northwest Highlands. Allegations include forced denunciation of their faith, pursuit to join state-run religious organizations, and the imposition of fines. Such pressure reportedly identified, especially during the period between May and August 2023. It has also been reported that individuals belonging to these communities have faced denial of key civil documents such as household registration, national identity cards, and birth certificate as punitive measures for refusing to renounce their religious beliefs. This has left some in a situation akin to the de facto stateless, depriving them of access to essential public services and legal protections. In light of the above, what measures are in place to ensure that individuals are free to choose their religion without coercion in accordance with Article 18 of the Covenant? How does the State Party respond to the reports that the denial of civil registration documents is being used as a form of punishment for the exercise of religious freedom? Additionally, the committee would also like to confirm whether the State Party has given any consideration to introducing provisions on conscientious objection. Let me move on to issue 21, which pertains to freedom of expression. The committee continues to attach particular importance to this issue as it was identified as one of the three priority concerns in the previous conclusive observations. In its 2022 assessment, the committee evaluated state parties' follow-up as E, noting the adoption of new legislation further restricts the right of freedom of expression. The committee remains concerned that several provisions in the state party's legal framework continue to unduly restrict freedom of expression. Article 109, 116, 117, and 331 of the Penal Code have reportedly been used to silence peaceful dissent with vague and overly broad language, allowing for arbitrary application against journalists, activists, and minority voices. The law on cybersecurity further enables censorship and surveillance online content, particularly when critical of the government. The press law defines the media as a tool of the state and prohibits content deemed to distort or defame the government, undermining independent journalism. The access of information law, meanwhile, imposes sweeping limitation on access to information of public interest. In its reply, the state party is also considering amendments to the law on press. But what amendment is the state party considering to the press law? Are any revision being considered to the aforementioned laws and provisions? Focusing on online freedom of expression, the committee takes note with concern of numerous reports indicating serious constraints on the exercise of online freedom of expression. It is reported the state party retains significant technical control over internet infrastructure through state and military-owned companies, which dominate the telecommunication sector. Such control has facilitated censorship and surveillance measures, including internet shutdown during sensitive events. The cybersecurity law and Decree 72 has reportedly been used to pressure a digital platform to remove content deemed critical of the government or the ruling party. Large volumes of online content has been taken down and heavy fines have been imposed on news outlets for publishing what authorities consider false information. The committee would appreciate the delegates' response to the following. Could the state party clarify what legal safeguards exist to ensure that measures affecting online freedom of expression, including censorship, content removal, or internet shutdowns, are strictly necessary and proportionate and in compliance with Article 19 of the Covenant? What mechanisms are in place to prevent and address harassment and intimidation of individuals, including journalists and online activists who express views critical of the government? Does the state party intend to revise the current legal framework to bring it in line with international human rights standards on freedom of expression? Issue 22 also pertains to freedom of expression. To begin with, the committee receives a report that cases of intimidation, reprisals against civil society actors for engaging with the UN and its human rights mechanism continue to be recorded, and that the state party has included in the annual UN Secretary General's report on intimidation and reprisals against individuals for their cooperation with the UN since 2014. How does the state party respond to these allegations? Regarding access to avenue for redress, the state party has not yet provided a response. The committee has received information indicating that there are currently more than 160 people imprisoned for peacefully exercising their basic civil and political rights, including a number of human rights defenders, bloggers, and environmental activists. The committee would also like to seek further clarification regarding the 2020 decree referred to in the state party reply. Also, as Mr. Ndai highlighted yesterday, the committee remains seriously concerned about the issue of transnational separation in relation to freedom of expression. Who was the authority to determine whether rights violation has occurred under the decree, and what criteria guide such assessment? given the reported involvement of state authorities in violation against journalists and others, does the decree apply to actions committed by the state institutions? How does the state party address the concern regarding transnational suppression? Lastly, regarding the case of Mai Fan Loi and 4 other environmental activists, the state party replies that the individuals are detained for violation of Vietnamese penal code, not for exercising civil or political rights for environmental protection activities, and that all 5 individuals have since been released. However, while the charges may have been formalistically based on the penal code, it has been alleged that their application was politically motivated. Such practices may have a chilling effect on the exercise of freedom of expression. In light of these concerns and to prevent chilling effect on the exercise of freedom of expression, could the state party clarify what measures it is taking to address such criticism in a transparent and rights-respecting manner? The committee also reiterates requests for disaggregated statistics data regarding this type of incidents. These are the questions I would like to raise at this stage. Thank you. I look forward to receiving your response.
Thank you very much, Mr. Teraya. These are all of our questions this morning. So I will give a 15-minute break, as I said, to the delegation to prepare the replies. The meeting is suspended for 15 minutes. Thank you. I will resume the meeting. So I'll give the delegation 1 hour to reply. I'll give the delegation 1 hour for replies. That will be followed by the follow-up questions and answers. Without further ado, we have the floor, sir.
Xin cảm ơn ngài chủ tịch, cảm ơn các thành.
Thank you very much, Mr. Chair, and thank you, members of the delegation of the committee. First, I would like to invite Ms. Jimai from Ministry of Religious and Ethnic Affairs to take the floor. Mr. Chair and distinguished member of the committee, in response to Mr. Fengnanek Niesa's question, firstly, I would like to confirm that ethnic minorities in Vietnam are entitled to all human rights and citizen rights of the Socialist Republic of Vietnam. At the same time, they are entitled to prioritized rights so that they can get equal access to public service. Since 2023 up to date, the National Assembly of Vietnam adopted more than 34 laws related to ethnic minority in a wide range of sectors, under which many regulations prohibit discrimination on the basis of ethnic grounds. In order to promote, equal treatment, in 2024, the government also adopted Decree 127, revising Decree 105 on ethnic affairs. In addition, Vietnam is now implementing the National Program on Socio-Economic Development for Mountainous and Ethnic Minority Area for 2021-2030. The first phase, 2021 to 2025, there are 10 projects, 14 sub-projects, and 12 schemes. Up to March 2025, Vietnam have established the Ministry on Religious and Ethnic Affairs. This shows the commitment of Vietnam to the ethnic affair and religious affair. Relating to a question by Mr. Niga yesterday regarding to whether ethnic minority are consulted before the law and policy are introduced, and also one question this morning, I would like to address these two questions as follows. Ethnic minority are given favorable condition to participate in political life and social life, and they can stand for election to the administration level. According to a report, the National Assembly Vietnam, the 15th, there are more than 100. There are 70% of the National Assembly members are ethnic minority, while the minority account for 14% of the population. That is the record, highest record ever. For the administration agency, there are a lot of leaders who are ethnic minority, and we have more than 50 ethnic minority representing themselves in the National Assembly, and also based on the principle of, for the people, by the people, and also the people monitor the public work. The ethnic minority also can participate in many political activity and also other activities. For the locality where we have a lot of ethnic minority, we can have a direct consultation or can be through the local governmental agency. And also thanks to the active engagement by the media agency, social agency, they perform the function of monitoring and overseeing the the issue related to ethnic minority. Regarding to the implementation of basic rights for the ethnic minority in Vietnam, we have a policy in order to encourage them to equally participate in public service area, for example, to promote their culture and identity, and priority given to ethnic minority and very few people, very low population ethnic minority group. And also we have a lot of favorable policy given to the promotion of their culture. We have a lot of non-material heritage owned by ethnic minority. For 2013 up to date, there are more than 80 heritage, owned by ethnic minority, recognized, and internationally UNESCO also recognized 4 heritage owned by the ethnic minority in Vietnam. In Vietnam, we have 4 geopark recognized by UNESCO, which are located in mountainous area of Vietnam, aim to the development of geopark and also to promote the development of identity and also the culture and the biodiversity of the mountainous area and ethnic minority areas. Ethnic minority groups are allowed to freedom of employment and they can have the equal payment, equal salary like others. The policy in Vietnam is also, aim at a promotion of vocational training for ethnic minority, which has been regulated by the employment law or vocational education law, just to name a few. Another question yesterday raised by committee member Ms. Basim asked about the right to get access to education and employment, particularly for Khmer and women. Khmer is one of the 53 ethnic groups in Vietnam that entitled to the overall education system of the country as well as other priority education program particularly allocated to them so they can freely join in the educational program of the country. It has a lot of positive implications. For example, those programs support the children of ethnic minority to get access to better education and have a more investment for the infrastructure development of the school and also to preserve and develop their own language. In the National Strategy on Development of Ethnic Minority in Vietnam 2021-2030, 5/5 target has been fulfilled successfully. So that are some of information I would like to provide in response to the question raised by the committee. Thank you very much. Now we'd like to invite Ms. Nga from Ministry of Religious and Ethnic Affairs. The freedom to select religion, Article 6 of the Law on Belief and Reason stipulates that everyone have the freedom to adopt and or not adopt a certain reason, and also it is prohibited to force others to follow or to renounce a certain reason. Regarding to the measure in order to ensure the freedom of reason, the law implementation in Vietnam regarding to belief and reason has been paid due attention to by the state of Vietnam, very effective from the center to local level. And based on the policy of the state party as well as the law, the authority in this area always ensure the freedom of religion by all citizens and also take proactive measures in order to ensure those rights, to ensure the unity among the members of the religion. The government of Vietnam and ministry in Vietnam also on a regular basis organized the activity to monitor the application of the law to see any violation occur or not. For example, from 2018 to 2024, since we have the law on reason and belief, we have hosted 85 conference and training courses for more than 12,000 participants. We have 110 seminars on law dissemination to members of the religion with more than 24,000 members of religion participating in those activities. We also had delivered and disseminate a lot of materials. We organize around 200 inspection trip and more than 1,000 monitoring activity in order to check the implementation of the law on reason, religion and belief. Regarding to decree number 95, it replaced of decree 126 and a number of provision under law on religion and belief. Decree number 55 revised a number of regulations to make it more specific and in line with the current situation and to facilitate the operation of religious organization. For example, they introduced the online form of collective religious activity and also facilitate different religious organization and individual to practice their belief and religion in certain scenario, for example, under the pandemic. And also decree number 50 95 also provide a lot of favorable conditions in order to allow the detainee or those under custody to practice their religion, and also introduce, a lot of new provision regarding to application. For example, they can send the application on the portal or by the using the portal service. Regarding to the allegation about the, requirement regarding to registration for collective religious activity, I would like to confirm that the state of Vietnam does not require them to register for collective or concentrated religious activities. That is based on the request by the religious follow themselves according to the law on religion and belief. At the place where so require they can register for concentrated or collective religious activity for the follower of such religion, and also for Vietnamese national or foreigner, where they not yet have a registered religious organization recognized by the state. They can apply for the collective registration procedure for collective religious activity so that they can gather at the establishment so recognized. The state will take responsibility to ensure security and order for the follower. That is not a legal barrier, but instead that is a condition for them to be recognized and protected by the law for Vietnam. Now there are around 5,700 sport for collective religious activity. Around 4,000 sport has been recognized by the state. It means that around 1,000 not yet register, maybe for many reasons. Maybe they fail to satisfy requirement or they don't want to register, but they still have the freedom to implement those activities if those are purely religious activity and not against the law. Now I would like to invite Mr. Chu Chung Dung from the Supreme People's Court Vietnam to take the question from the members of the committee. So members of the committee, I would like to take two questions. Firstly, regarding to judicial independence, and secondly, juvenile justice law in Vietnam. Firstly, regarding to judicial independence, I would like to confirm that the Constitution 2013 is very clear. The Court of Vietnam is the adjudicative agency of Vietnam exercising judicial power. It is clearly provided in the Constitution, Article 102, and the court only obey the law and follow the law in this process. Regarding to the measure to strengthen judicial independence, I would like to introduce the most updated changes in the law organization of the People's Court 2024. There are new, provision regarding to appointment of judge, so that judges can be more independent. For example, the criteria for the candidate stand for the position of the judge. They need to satisfy professional and moral requirement, and they must be trained in terms of professional adjudication skill. They need to sit examination, the national, recruitment examination. Those are those can satisfy those requirements will be considered by the National Council on judge appointment, and they will be referred to the Chief Justice of Vietnam and later to be approved by the state president. So for those people after being recruited, they will be approved by the National Assembly, and also the decision on appointment is made by the state president. So you can see that is a very vigorous and very stringent procedure, and judges are independent. They comply with the law only. What about the working term? Under the law on organization 2024, they can be appointed for a term of 5 years, and after 5 years, they can be appointed for life until they retired. And similarly, justice for the Supreme People's Court will also be appointed for life, and they will be independent. They will comply to the law only, and interference with judicial activity are prohibited according to Article 103 of the Constitution. The National Assembly, the Fatherland Front, also provide the function of overseeing the performance of the court, whether the court only comply to the law or not. So the general policy of the Vietnam now is that there will be no exception. For example, in the fight against corruption, there are a lot of cases where a lot of strict judgment has been rendered against high-ranking officer, and those cases are widely published on media. The new law on organization of the court also ensure the right of equal before the court, and also the court must be fair, transparent, and conduct the hearing in a timely manner. And the adversarial principle must be respected, and also the right to defense counsel, and also legitimate right of the witness. Also, the victims must be protected. Those principles are well illustrated in the Penal Code of Vietnam. The Criminal Procedure Code of Vietnam also provides for the procedure for deciding cases under the supervision of the procuracy regarding to the procedure applied. For less serious crime, we also have a timeline, for example, within 30 days or 45 days. And for serious crime, it will be within 2 months. For extremely serious crime, it can be within 2 months. It can be extended once, but not more than certain time limit, for example. So within 15 days, after we have the decision to initiate the trial, the court need to conduct the hearing, and in Spencer cases, this time limit could be 30 days. And for appellate cases, the trial must be conducted within 4 months, for example. For summary procedure, the trial must begin within 7 to 10 days. So those numbers aim at proving that those procedures implemented by the court must be consistent with the law, and it's under the supervision by the prosecutor. So there's no case of shortening the trial. At the same time, we also mentioned about the guarantee of adversarial proceeding. And also the arrangement of the layout of the court also has been introduced. For example, the defense counsel and the prosecutor will sit on the same level, opposing each other to show the fairness among the party. Any activities that hinder the judicial procedure by the court will not be punished by the law. At the same time, I would like to inform you that the Vietnamese law also provide regulation on legal aid service available to certain people. We have Legal Aid 2007, and this law is now being considered to be revised and amended. And Ministry of Justice of Vietnam now is assigned with the function of revising this law. Let me move to the second issue, juvenile justice issue. We have the new juvenile law adopted by the National Assembly of Vietnam in November 2024, which will take effect in June this year. Sorry, we will take effect this year, 2025. So this law is very consistent with the international standard on juvenile justice. Make sure that we have a more humane approach when it comes to juvenile-related cases. This law provides a lot of, new regulation in order to better protect juvenile offender and juvenile victims, juvenile witnesses in criminal case related to them. And also this law provides a lot of diversion measures in order to apply it to juvenile offender. And a lot of new such alternative or diversion measures are included in this law. And also, those measures will be flexibly applied by the court in a timely manner to prevent any damage caused to them. And also the law also introduced two juvenile-friendly measures, including offender and victims, to make sure that the procedure will be more victim-friendly or offender-friendly. And also a lot of new regulations are included in this law on juvenile justice. Regarding to punishment and penalty against juvenile offender, for example, reprimand or non-custody measure or fixed term imprisonment. And also fine could be applied if, such offender they have access, and also reduce imprisonment against juvenile, for example, from 12 years to 9 years in certain cases. So juvenile kept in detention or prison, they will be kept separately, and the prison guard or prison officer must be trained in terms of juvenile justice, and also a lot of supporting service will be provided to those person after they fulfill their obligation after they serve the penalty. We also develop a manual on juvenile justice in criminal cases available for judges and court clerk. Up to date, we have 38 juvenile court at provincial level. By September 2024, we have 207 judges and court clerk and staff working at juvenile court in Vietnam. We also pay a lot of attention to training and capacity building to those judge and court officers so that they can better perform their function at this specialized court. Now I would like to invite Mr. Dung from Ministry of Tourism, Sport and Culture. So distinguished member of the committee, Vietnam is one of the country with rapid, development of internet and high percentage of internet user. We also have very good internet technology infrastructure, but along with the high percentage of internet use, it also means that there will be questions related to personal data, question. It requires us to have a better mechanism to ensure confidentiality of personal data in line with Constitution and international convention. That's why we have cybersecurity law, and the government of Vietnam also have introduced Decree number 13/2023 regarding the protection of personal data. The purpose of this decree is to better protect, data of the individual, organization, and agency to strengthen cybersecurity in the process of digitalization in Vietnam, and also to facilitate the development of e-government, and to make sure that information will be collected in line with the international standard on data protection. Vietnam has to consider carefully on the input provided by domestic agency as well as international agency to make sure that data protection will be safeguarded in Vietnam in line with our situation, and also in line with the international commitment that Vietnam has made. At the same time, it will not hinder the data flow. At the same time, it can protect privacy for individual and organization, and also facilitate economic investment. I would like to update you that in June 26, the National Assembly of Vietnam, the 15th National Assembly, officially adopt the law on protection of personal data. That is a strong commitment of Vietnam when it comes to protection of privacy and personal data in the area of digitalization. 39 article, 5 chapter, those are some information of this law. It will take effect next year, 2026. This is the very first law in Vietnam aiming at better protection, personal data in line with international standard. This law specifically provide for the rights of data owner, for example, the right to, agree for the use of their data and withdraw their agreement, and also the right to request for elimination of data about them, and also the right to file complaint if such rights are violated. And also this law allow the monitoring and overseeing function to certain state agency, and the law also requests service provider as well as business and agency when they deal with Vietnamese citizens' personal data to comply with Vietnamese law. This law satisfy requirement, and also this law also once again confirm that Vietnam act in line with ICCPR as well as other international conventions regarding to the freedom to expression, freedom of speech. We continue to affirm that Vietnam we ensure and safeguard the rights to freedom of expression and freedom of speech. In our country, we consistently implementing a lot of measures in order to ensure such rights for our people. The effort made by Vietnam Vietnam has been recognized by international community. For example, we have in Vietnam a lot of media agency, and as mentioned by the head of the delegation yesterday in his speech, in addition to the rights, of course, the people in Vietnam need to fulfill their obligation. They cannot misuse or abuse the right of freedom of expression to violate the legitimate rights of others and also the rights of other agency and organization. The freedom of expression is not absolute rights. It means that there are certain restrictions provided by the law. It has been confirmed in Article 19.3 of ICCPR and Article 29 of the International Declaration on Human Rights. So with the current situation of globalization, and we face the issue of fake news or distorted information, and in the context of information war, the potential of information war, Vietnam need to implement different measures in order to protect our national security as well as social order. A number of portals, websites, particularly transnational portal and website, they have a bad, intention against the state of Vietnam, and they produce a lot of misinformation or distorted allegation against the state of Vietnam. Therefore, we need to apply technical measures to deal with this. I would like to confirm once again, Vietnam is that the consistent policy of Vietnam and the law of Vietnam safeguard the freedom of press, freedom of expression, freedom of, speech, but it must be in line with the international law. For example, Article 19.3 of ICCPR, the cybersecurity law in Vietnam is not, against those commitments. For example, when it comes to the exemption under this law, those exemptions are very much consistent with international commitment as well as other agreement that Vietnam is a signatory. So those are some of my input to clarify a number of questions raised by members of the committee. Now I would like to invite Ms. Hà Thị Minh Đức from Ministry of Home Affairs to take the floor to clarify other questions. Thank you, members of the committee. I received a number of questions regarding to the freedom to association as well as the election. I would like to provide a number of information to clarify those questions. And also I will address, as you know, the question of human trafficking in employment sector. Regarding to the right to freedom of association, we'd like to update you. The right to freedom of association is one of the most basic right to Vietnamese national, and it has been clearly provided by the law, by the government, through the adoption of a number of decrees regarding to this right. Decree 126, 2024 stipulate about the operation and management of association. It has institutionalized the policy of the state and the party to facilitate the right of freedom to association of the people in line with the penal code, the constitution, as well as relevant legislation. By 31 December 2024, Vietnam has more than 70,000 associations under which 609 associations operate nationwide. More than 69,000 associations operate at local level, at different level, and also cover a wide range of sectors, for example, commerce, economic, and also financial, educational sector, medical sector, cultural and sports sector, environmental sector, and humanities sector as well. We also recognize that there's increased number of association, and they act in a wide range of sector, sector in order to satisfy requirement of the people, and they comply with the requirement of the law. Those associations, promote their roles as the agency protecting legitimate rights of their members and the people as well. They conducted a lot of activity that contribute to the socio-economic development of the country. We also would like to update you that regarding Decree 126 that I mentioned from the beginning, this decree specifies those rights by the association to ensure their operation, and this decree is implemented in a transparent manner to benefit the people and the country. The requirement on registration and report on their financial resources, and the charter must be recognized by the authority. Those are very popular regulations adopted in many countries to prevent any potential violation of the law by association or any potential abuse of such a regulation for illicit activity, for example, financing terrorism or to conduct money laundering. This decree has no provision discriminate religious, organization or religious follower. And also, those regulations aim at, administrative management only, not to eliminate anyone or discriminate anyone on the basis of their belief or religion. The state of Vietnam always respect and also make sure that the freedom of religion and belief will be safeguarded in line with Article 24 of the Constitution 2023, as well as other related legislation. Regarding to the question on, election, stand for election to ensure the principle of transparency, or the question of proxy voting, we would like to provide with you the following information in order to ensure the transparency and substantive election. The National Assembly of Vietnam, that is the highest people's elected agency, they established the National Election Council. When it comes to election, if we detect any violation, the National Election Council will make the decision on, dismissing those election and to rehost the election, and also to introduce penalty against those persons engaging in such a violation. So the council is under the monitoring and oversight by the National Assembly, and the permanent committee of the National Assembly also actively engage with other governmental agencies, for example, the Fatherland Front and other agencies, in order to conduct their monitoring activity. The decision will be made on majority basis. In addition to the legal framework, in order to ensure the transparent election process, we also have in Vietnam available mechanism to deal with violation, including the mechanism to criminally prosecute those individuals and organizations violate the law on election, in order to ensure the democratic and transparent election. Vietnam introduced a lot of voting principles, according to which the voter need to vote themselves. They cannot ask others to vote on their behalf. Only in certain circumstances, certain exemption. For example, they are ill, they suffering from illness. They cannot go to vote themselves. Accordingly, we also introduce measures to make sure that vulnerable groups, they can vote for themselves. For example, we can bring the voting box to their residential place so they can cast their ballot. We would like to inform the committee that the 2021 election, 2021-2026 election recognize the highest number of voters ever. So 99.6 voters nationwide have been voting in this, election. The National Election Council, as well as the other supporting agencies, on a regular basis, they monitor and give a timely direction to eliminate to address any challenges. Therefore, there's no case of serious violation. We also want to confirm once again that we encourage voters to select the candidate that satisfy the requirement for the position. We also have the law on election of member of the National Assembly and also the agency of local level introduce a very stringent procedure for such an election. The candidate need to be verified and must be gone through a very strict scrutiny, and also they will be elected on a very transparent and democratic procedure. So such a procedure have the engagement of the people at local level. The state party, the Communist Party of Vietnam, with the roles of leadership, they also can introduce a number of candidates who are members of the party. But that is also one of the pool of the candidate. It does not eliminate to have a more candidate from non-party, organization. In fact, we have a lot of people elected who are non-party members. The election and stand for election in Vietnam has been well organized in Vietnam and has been well recognized by the people. Vietnam also introduced a lot of regulation and provision regarding the procedure for standing for election under the law on members of the National Assembly, for example, to ensure the right of freedom of standing for election. There's no restriction, and they will are entitled to the same equal treatment. The state authority will need to create favorable conditions for them in this process. So those activity are well received by the people because it is for the benefit of the people, and the people is considered as the master, and also at the same time beneficiary of this process. For the National Assembly member election 2021, there are 9 candidates stand for the election, and 4 of them successfully elected as the member of the National Assembly. Regarding to one question about human trafficking prevention in labor sector, the law on Vietnamese guest worker, contract-based Vietnamese guest worker 2020 introduced a number of provisions in order to better protect Vietnamese guest worker working abroad, and accordingly, recruitment fee must be eliminated. It, prohibits service provider to collect brokerage fee, and they only can collect service fee by sealing fee only after the worker sign the contract with the employer. The deposit of fund from the worker must be sent to a dedicated fund, and it will not be frozen. And the worker will be provided with such a deposit in addition to the interest rate provided to them after they finalize their contract. We also have implemented a lot of negotiation with our partner to make sure that limited fee will be paid by the worker, and also in the future. That we're moving forward to a model where employer will pay those fees. We also have implemented a lot of communication campaign to make sure that potential guest worker, they understand the risks of such cases, and they understand more about the risks of being trafficked when working abroad. We also have the scoring system to score the performance of service provider. and also to make sure that we can introduce more information to the potential guest worker about the reliable channel for migrating abroad to work abroad to reduce, the risk of being trafficked if they go under an officer channel of migration. So that's all for me. Thank you very much. Thank you very much. And now we would like to invite Ms. Ha from Ministry of Public Security to share more. Regarding to the question on civic space for civil social organization in Vietnam, I would like to inform that, association and organization in Vietnam have the freedom to operate diversely. They are facilitated by the state and they play a more and more important role to provide criticism on the draft law and policy of Vietnam. They also make contribution to socio-economic development of the country at both central and local level. Vietnam facilitate the operation of such organization and association as long as they act in line with the law. We like to confirm that in Vietnam, no individual are arrested or adjudicated or prosecuted because of their membership of the civil social organization, including human rights defender and journalists. Only those that violate the law, they will not be arrested and they will not be prosecuted in line with the law in environmental sector as well as other civil sector. Those individual and organizations need to comply with the law and they need to fulfill their obligation, including the obligation in tax sector in Vietnam. Over the past few years, we addressed individuals that, violate the regulation on tax evasion. They just violate criminal code of Vietnam and tax regulation of Vietnam. They are not arrested for the reason of their membership of, civil social organization, and their arrest, detention, prosecution, and adjudication has been implemented in line with the law. Those are public cases and information are published on, public media channel, and also they admitted to their violation and they are subject to clemency policy. Regarding to the case of Mai Văn Lợi mentioned by one member, he was investigated for tax evasion charge, and thanks to the state clemency, he was released in September 2023, and now Mai Văn Lợi is a regular citizen in Vietnam with full interest and full rights, including the rights of expression, the rights of freedom of speech, online expression and online speech. Thank you very much. Now I'd like to invite representative from Ministry of Public Security, Mr. Ngô Đức Thắng. The floor is yours. So, Mr. Chair and members of the committee, regarding to the question of human trafficking, allow me to share the following information. Vietnam is a member of the International Convention and TIF Protocol, and Vietnam have introduced anti-human trafficking law 2011, and in the most recent meeting of the National Assembly, we revised and amend the anti-human trafficking law. This law, amended law, has been adopted in 2024, taking its effect since January 2025. And this newly amended law is consistent with the protocol that I mentioned earlier. In particular, we revised the definition of human trafficking to make sure that it's compatible with international convention. And also under this law, victims of human trafficking, including two groups. First one, those above 18 years old. For those groups, there are three conditions. There must be, offense and also purpose of the offense, and there must be trick used for human trafficking against person under 18 years old. Only one element, two elements, the offense and the purpose, and there's no need to prove the trick. It means that even the person under 18 years old, they agree with the offender will be also prosecuted for the crime of human trafficking. And in the time to come, we will continue to revise out the criminal code. The criminal code under Article 150 and 151 regarding to human trafficking, and also human trafficking against the person under 18 years old. We are going to divide these two articles of the criminal code to make sure that it is consistent with the law on anti-human trafficking adopted recently by the National Assembly of Vietnam regarding to supporting service available to the victims of human trafficking, and also those person under the process of being identified as the victim of human trafficking. We extend the supporting service available to not only victim of human trafficking, but also those person being identified. It means that anyone who report to the authority claiming themselves to be victims of human trafficking, they will be protected, they will be supported right away. So that is also a newly positive change in our law in providing support to the victims of human rights trafficking. At the same time, under this newly amended law, Article 29 also mentioned about the rescue and also identification of victims, Vietnamese victim abroad, and also the foreigner coming back, being trafficked in Vietnam. Article 31 mentioned about the process of identification and also rescue and also transfer of foreign national being trafficked to Vietnam. Among those articles, the victims will be provided with supporting service, for example, necessity requirement, medical supporting service, and also psychological supporting service, and also translation service to foreign victims. Regarding to the context of the fight against human trafficking in Vietnam, we emphasize on communication campaign, in particular in mass public media with a diverse channel, diverse methodology. Since 2019 until now, we have hosted more than 100,000 public communication section, and we have more than 1,100 communication club, central and local level. We also have provided more than 100,000 copies of training materials and more than 150,000 documents, for example, relief to the public in general about the topic of anti-human trafficking. We, on a regular basis, also have a lot of campaign to repress human trafficking. We work well with the border and the police of the neighboring country in order to jointly organize those activities. In 2024 alone, Vietnam investigate more than 163 cases involving more than 400 defendants and victims. By 2023, Vietnam established more than 400 social establishment, including both public and private establishment, in order to support victims of human trafficking, to provide them with shelter and temporary residential address so that they can be supported in terms of legal need and also psychological need as well as medical needs also. From 2012 to 2023, there are almost 8,000 victims being supported by agency and organization in Vietnam. We also have many other methodology to support the victims. A lot of projects are funded by international organizations. For example, the model supporting victims of human trafficking, or the models supporting women to prevent the risk of HIV infection or being trafficked as a sex worker. Regarding to freedom of movement, I would like to share the following information. Firstly, I would like to confirm that Vietnam respect to the maximum the freedom of movement for Vietnamese citizens. It has been provided in Article 23 of the Constitution and Article 5 of the Law on Entry and Exit of Vietnam, to ensure that Vietnamese citizens will be protected, including the freedom of residence and freedom of movement. The law also clearly provided, a list of prohibited activities, prohibited acts, For example, if anyone wants to depart or leave Vietnam, they need to comply with the law on entry and exit. If any violation detected, it depends on the seriousness of the violation. The authority in Vietnam will handle such a case to ensure national security and social order. In fact, ethnic minority and religious minority prevented from leaving Vietnam because simply they violate the law on entry and exit, or they violate the law regulation on national security, not because of the ethnic or religious nature of those persons. We act in compliance with ICCPR and other international conventions. Accordingly, freedom of movement can be restricted on the basis of national security, national defense, or public health, and such a restriction decision must be made by the agency in charge with full authority. In Vietnam, there's no single case of restriction of freedom of movement because of the reason of human rights or ethnic or religious, reason. In many cases, they are not allowed to leave Vietnam because they, not yet fulfill their obligation, for example, tax obligation, or they violate the law and other legislation regarding to the national security. It has been clearly disputed under Article 36 of the law on entry and exit of Vietnam. So that's all for me. Thank you very much. Mr. Bernang from Ministry of Justice, the floor is yours. So, distinguished member of the committee, regarding to the question about the age of juvenile in Vietnam, allow me to provide additional information as follows. The law of Vietnam provides about the age of children. Those are under 16 years old. And for juvenile, is under 18 years old. So according to the law of Vietnam, we have 3 levels. Firstly, for those under 14 years old. Secondly, for those from 14 to 16, and thirdly, the policy applied to those from 16 to below 18. We have, suitable policy and legal provision to be applied to those 3 categories of juvenile to match their physical as well as psychological development. For criminal justice, we have 2 groups applied to both victims and offender. For those offender, the criminal law in Vietnam stipulate for those from 14 to under 16, they are liable for certain offenses. Only 28 offenses. So for those not in the list of 28, they will not be criminally liable, but otherwise they will be referred to other mechanism. For those 16 above, they will be criminally liable for the offense provided by the criminal code. We also have a separate law on juvenile justice, and under this law, we also stipulate 11 diversion measures to be applicable to them. Under this law, we also clearly provide for the mechanism and procedure for any cases involving juvenile. We have a mechanism to review those cases in details to see if it's suitable to be referring to diversion mechanism or not, without the need of having them to go through criminal proceeding. Only in case after reviewing by social worker, by the court, by the procuracy, it is not suitable to be referred to diversion mechanism, they will be handled criminally accordingly. Another question regarding to Article 109, 117 and 131 of the Criminal Code regarding to freedom of expression. The Criminal Code of Vietnam have established a very clear threshold regarding to exercise of freedom of speech, freedom of expression with, other violation of the law. Accordingly, one person will be considered to be, violated the right to freedom of expression and freedom of speech in order to violate the national security, national defense, and also the legitimate right of others. In such a case, they will be criminally prosecuted. For example, those established or join the organization with the purpose of overthrowing the people's administration, they will be prosecuted for the crime of overthrowing the people's administration, or anyone abuse the right of freedom of expression, freedom of speech, freedom of belief and religion in order to infringe legitimate rights of the state, of organization, and other legitimate rights of others, they will be criminally handled or prosecuted. We also come to see that each country, they will have their own way of doing things, but they share the same principle, and they think that infringe upon the national security must be strictly handled. Accordingly, Vietnam on way facilitate the exercise of the freedom of expression, freedom of speech, freedom of provide criticism and provide feedback on the policy and the law of the country. But at the same time, we are very consistent to strictly deal with the case of abusing those rights in order to oppose the state or to defame the state or to cause division among different groups or different organization of the country. It is in line with ICCPR article number 19 because this article introduced certain exception to be provided by the law in order to make sure that anyone need to respect themselves, but at the same time not to respect others. And those are some more additional information from myself. Thank you very much. Now we would like to invite Ms. Phương from the Supreme People's Procuracy to provide additional information. So, member of committee, regarding to the question on how we can ensure the rights of detainees. The basic for application of those measures is under Article 119 of the Penal Code. Accordingly, the detention is only applied in case of necessary when we have a clear and obvious ground that they may fall away or they may hinder the judicial proceeding or they can commit a crime. And the application of other measures, for example, the measure of not allowing them to leave their residential address is not feasible. The detention of juvenile, according to Article 419 of the Criminal Code, the detention measure of, against a person under 18 years old must satisfy four requirements. Firstly, only in case of necessary. Secondly, other measures are not feasible. So those are two general requirements. At the same time, there are two other requirements. The time limit cannot be more than 2/3 of the detention period of the adult. And when there are no ground for application of such a measure, such a detention measure must be ended, and other diversion measures must be applied. And the detainee reserve to, they have the full right to family visit and also the right to communicate with others. For example, regarding to Article 74 of the Criminal Procedure Code, the detainee or the person held in custody, they will have the right to get access to defense counsel at the beginning of the detention. However, in certain cases related to the national security charge, the Prosecutor General of the Procuracy, may issue the decision in order to allow defense counsel only to participate at the conclusion of investigation. That is in line with the international convention, in line with the, cases related to state secret or the state security related issue. At the same time, in addition, those measures should not be understood that this will be applied for all, criminal cases related to the national security, but it only apply on a narrow scope. Only in case of necessity, this measure will be used to make sure that this power will not be misused. And only the Prosecutor General of the Procuracy of Vietnam will have the power to issue such a decision regarding to the time for detention and extension of time for detention. It is under Article 173 of the Penal Code. At the same time, according to Article 173.5 for national security related cases, only in case of necessity or extremely, severe criminal cases, the Prosecutor General of the Supreme Procuracy can extend the detention at the conclusion of the investigation. The rationale for this measure is that for extremely severe criminal cases, including national security-related cases, the investigation can be very complicated. So at the end of the initial investigation phase, there's a need to continue the investigation. So the detention can be extended. The extension of detention time, is to ensure that the investigation will be thorough, will be sufficient, and also the Prosecutor General of the Supreme People's Procuracy has the power to make the decision on the extension of detention, and this decision is made in a transparent manner to safeguard human rights and citizen rights of those person involved, to make sure that it is in line with Article 19 of ICCPR. Since 2019 up to date, we have no case of misuse of this power, or we have no case of abusing of this power. So I can confirm that in Vietnam, there's no case of prolonged or arbitrary detention, period detention, or extension of detention against the law.
And I'd like to open the floor to the members who wish to take the floor for the follow-up questions. Mr. NDIA, you have the floor.
I'd like to thank the chair and, of course, the Deputy Minister of Justice and the representatives of the Ministry of Justice and the representative of the Ministry of the Interior for the replies provided. But I have to confess, I'm not fully satisfied on a few questions, and I will highlight them now. The first, who is responsible for the disciplinary procedure for judges, and how do you guarantee their independence from Parliament and from the party? I don't think I heard an answer to that question. Secondly, how do you respect the presumption of innocence and access to a lawyer in sensitive cases? How do you also guarantee protection for lawyers working in sensitive cases from facing any kind of threat or reprisal? And then finally, could I have some disaggregated data on legal aid? I'd asked these questions, but perhaps if you don't have time to do so now, you can send the answer in writing. And then I also am waiting for a response on the procedure to follow for a candidate who's not a member of the party and who wants to stand for election. Can they do that, or do they need to have approval of the party? I also would like to hear about the independence of the National Electoral Council, which apparently also works under the authority of the National Assembly. So if possible, I would like to have some clarification on these points. If you cannot do that now, then in the next 2 days before the deadline for submission closes. Thank you very much.
Thank you very much, Mr. NDIA. I'll give the floor to Mr. Teraya.
Thank you. Thank you, Mr. Chairperson. I would raise several issues. First is on the freedom of expression. Of course, the freedom of expression is not absolute under Article 90, Paragraph 3, as the delegation mentioned, but the concern lies in the breadth of the restriction imposed by the state party. In this regard, General Comment 34 provides useful guidance. It states that it's in paragraph 34, the same number, restriction must not be overbroad. And further, when a state party invokes a legitimate ground for restriction freedom of expression, it must demonstrate in specific and individualized fashion the precise nature of the threat and the necessity and proportionality of the specific action taken, in particular by establishing direct and immediate connection between the expression and the threat. Of course, there are matters that must be addressed on a case-by-case basis, but for example, if the allegation is just a distortion of information, it's of course, if that's just one of occurrence, it should not automatically lead to measure such as shutdown or similar severe action, especially when the expression in question may amount to legitimate criticism of the government. In other words, any restriction by the state party should be as limited and narrowly tailored as possible. The committee would like to appreciate clarification as to how this requirement is being adequately taken into account. Actually, of course, the one of the things the delegate mentioned is the very many kinds of many broadcasts and many publishing house. But if even if so, that the such a broadcast is just registered or permitted by the severe standard, the meaning is not very ample. This is just a matter. The matter is not quality, but the matter is not quantity, but just, of course, the quality. In this relation, I know the Vietnam State Party is now the host of the UN Convention Against Cybercrime, maybe which is expected to be known as the Hanoi Convention, while many concerns have been raised by human rights NGO regarding this treaty. It is nonetheless significant that Article 6 of the Convention, entitled Respect for Human Rights, provides consistency with their obligations under international human rights law. I now turn to the specific issue of the case of environment activists. The committee does not, of course, take issue with the existence of criminal penalties for violation of tax law. The concern lies in whether the measures taken were proportionate, whether similar actions have been applied consistently in comparable cases, and whether there were any other forms of unjustified human rights violations, such as harassment of the activist family. If the state party has any additional information on the matter, it will be very appreciated. Lastly, I still have the forming the questions, but the delegates answer to about the religious freedom, and actually there are many information for me, but at the same time the response seems very broad and not specific, such as the issue of the, for example, conscientious objection, and also how to register it, and also the reason why one of the biggest or two of the biggest religious group is not registered yet. It sounds strange. It looks strange from outsiders. So there would be some problem there. Again, again, the state party justifiably recognized the issue, recognized the importance of religious freedom, but at the same time, that was under the registration of the state party's law. So that is the same. That is the same as the selection of the freedom of speech. Maybe that's all. Thank you.
Thank you very much, Mr. Raya. Now I give the floor to Mr. Igeju.
Thank you, Chair, and I'd also like to thank members of the delegation for responding to my to the question I posed, but I'm still not clear on some of the responses given, especially on what I questioned on the laws, criminal procedure laws of Article 74 and 173, in particular, subparagraph 5. It's the response I got is that this is an exceptional, it's under exceptional situation that these are applied for people who are arrested for national security reasons. I'm not sure how this is interpreted as, this is a broad concept. So, and I understand that many, the information we have, for instance, is that there are, these cases have applied, for instance, to persons or prisoners of conscience, we can say, for on religious beliefs. I don't know whether these are extremely dangerous people that are arrested for national security reasons. And even if a person is arrested for national security reasons, I don't understand why a person cannot have access to a lawyer, incommunicado detention up to the end of its investigation. This, I understand that the response was this was in line with the international human rights law, but actually Article 9 doesn't provide that of the covenant. I mean, I don't think it is. And the other response given was that to date there are no cases of arbitrary detention received. I mentioned the opinion given by the working group on arbitrary detention on Vietnam, and I mentioned 27 opinions. I've read all of them. And these have applied not to dangerous, I'm not sure whether land rights activists, journalists, and so forth. This was and the working group on arbitrary detention found a violation, a claim of these claims of arbitrary detention in various reasons. There was a lack of access to legal counsel, denial of medical treatment, restriction on freedom of religion, as I've said, and these are consistently, these were the decisions made. My question is, have you considered this do you consider this as a violation? Have you considered implementing the opinion of the working group on arbitrary detention, or do you think that these are not a violation of arbitrary detention? So that's probably, I need some more clarifications on these. Thank you.
Thank you very much. I'll give the floor to Mr. Fernandez Lieja.
Gracias. Gracias.
Thank you very much to the delegation for the answers that they've provided as part of this constructive dialogue. I would like to just touch on a few of the issues that haven't been entirely clarified in my view. First of all, on the right to freedom of association, I would like to know whether any of the restrictions to freedom of association could be removed, and whether you're envisaging any law on freedom of association. Now, association well, it has a dimension in Vietnam relating to minorities, relating to Article 92 or 97 and the 1992 declaration relating to minorities and language minorities. So there is a transnational dimension to this. Now, according to information that's reached the committee, minority associations or indigenous peoples associations are not allowed to participate in international fora such as the United Nations Permanent Forum on Indigenous Issues, and that is a matter of concern for us. So I would like your comments on this. And then I have a further comment in relation of the rights of indigenous peoples. I don't believe you've addressed the concern as to whether any of the rights that have been developed globally on the rights of indigenous peoples and minorities, I would like to ask to what extent these rights are recognized in Vietnam. It seems that there's a difficulty in recognizing the very existence of indigenous peoples. I'm not clear, and I don't think the committee is clear, as to whether indigenous peoples are recognized as existing in Vietnam. And we would like to know whether they benefit from the core rights that are recognized in international law pursuant to Articles 27 and 1. Thank you.
Thank you very much. I'll give the floor to Madam Basim.
Thank you, Mr. Chairperson, and I would like to thank the delegation for providing more replies, particularly as far as situation of women and their empowerment. Some replies about the right to privacy, but I still want to further clarify what are the conditions where the government does interfere with the right to privacy by cutting telephone lines, interrupting cell phones and internet services of political activists and their family members. On the other hand, does the government of Vietnam considers at any time abolishing or amending or providing more solid grounds for the registering, or what it implies that the media users should register using their real names and phone numbers. And it seems that this mandate applies to all users, including those outside Vietnam. So does the government think, or in the future, think about abolishing this decree number 147 of 2024, articles 23.3 and 27.3 concerning the identity of the users? Thank you very much.
Thank you very much, Madam Basim. These are all the follow-up questions today. So we now have about 24 minutes, but we have some time for conclusion. So I'll give you 17 minutes to reply. You have the floor.
Xin cảm ơn câu hỏi của các vị.
So thank you very much, the committee, for raising additional question. Allow me to invite Mr. Chu Dung Dung from the Supreme People's Court to take the floor to address the question first. So, distinguished member of the committee, allow me to take the question about the presumption of innocence principle in criminal system of Vietnam. It is under Article 13 of the Criminal Procedure Code 2015 of Vietnam. This principle allow the defendant to be innocent until they are declared guilty by a legally valid judgment by the court of Vietnam. When there are no ground or no evidence to declare them to be guilty, the authority, for example, the court must declare them to be not guilty or to be innocent. That is the nature of the principle of presumption of innocence. So this principle allow the defendant to be, always innocent until there is a legally valid judgment by the court. So that is the nature of this principle. In other words, only the court will have the authority to declare someone to be guilty or not guilty, while await for the judgment to be rendered by the court. They are presumed innocent, and they must be provided opportunity to defend themselves and to get access to, defense counsel and other service. Second element, when there are insufficient ground or where there are lack of evidence, the authority, for example, the court need to declare them to be not guilty. Any doubt must be, interpreted in a way to be favorable to them. So in the process of adjudication, if there is lack of evidence or there's lack of ground, the court will need to declare them to be innocent. So that is our way of interpretation of the principle of presumption of innocence. Second question. Regarding to investigation of violation by judges, for the court, we have many mechanisms to oversee and monitor the performance of the judge. We have an internal inspection. We have an inspection department within the court, and this department, they have their working agenda annually to conduct inspection, against local and central court. The second mechanism is investigation mechanism. If we receive any denunciation or allegation of violation made by the judges, it is a very strong mechanism, stringent mechanism by the Supreme People's Court of Vietnam. In fact, there are cases where judges were criminally prosecuted for their violation of the criminal code. So that is the second mechanism available in order to conduct, disciplinary action against judgment. So if you still are interested more about those issues, we will provide answer in writing within 48 hours. Now I would like to invite Ms. Hà Thị Minh Đức from Ministry of Home Affairs. The floor is yours. So, distinguished member of the committee, regarding to the question, asking me to clarify further about independence of the National Election Council, I would like to confirm that this council is independent without any interference from any individual and organization. Article number 13 of the law on election mentioned about the operation of the council. They will make the decision on majority vote, and their meeting will only be conducted when they have more than 2/3 of the members, and on the decision will be only legally valid if it is approved by more than 50% of the member. They will report before the permanent committee of the National Assembly. Regarding to the mechanism for standing the election, the independent candidate, they need to prepare their dossier or application and send the application to the authority at the their location. So when review their application, if the application satisfy the requirement, the law, the National Election Council will send their document, for example, their CV or their asset declaration, and so on to the Standing Committee of the Fatherland Front and also the provincial election committee at the provincial level will send such a document to the National Election Council together with other related documents about themselves. So there is a very stringent procedure for considering the application by independent candidate. Next question. Restriction on freedom of association, whether we will remove such regulation or not. We have recently enacted Decree number 126, which we believe that create favorable condition for association to operate within the law to ensure the principle of transparency in the management of those associations without any discrimination against them. We can see the number of associations in Vietnam increase day by day. Therefore, for now, we not yet have any plan to introduce any other new law because the current legislation available satisfy, the requirement. So we have no plan to introduce any other new law in the time to come. Thank you very much. Now I would like to invite Mr. Đinh Tiến Dũng from Ministry of Tourism, Sport and Culture. The floor is yours. So, members of the committee, allow me to introduce additional comments and information regarding to the privacy or cybersecurity and also freedom of expression, freedom of speech. As I mentioned earlier, the policy of Vietnam is that to have a very healthy cyberspace that will not infringe on national security, national defense, as well as the social order, and also to safeguard legitimate rights of individual and organization. In the global context of having a lot of cyber attack, which are very serious, which threaten directly to the national security of all the country all over the world. So internet development must be in line with the strict management to ensure the safety. Therefore, the cybersecurity of Vietnam aim at, promote the advantage of internet, but at the same time to strike a balance between, ensuring legitimate rights of the country and of the people. So cybersecurity law has been developed on the basis of consulting widely and also on the basis of learning experience from other countries. The Ministry of Public Security, in line with Ministry of Justice of Vietnam, working together to introduce guidance document regarding to implementation of the cybersecurity law. Under this process, we consult the private and public agency. Decree number 53, for example, give a guidance on, requirement for taking down of the content which are in violation of the national security or in violation of legitimate rights of individuals and organization. Cybersecurity law provide in details cases where they can take personal information or personal data for the purpose of handling national security related cases. And also under Article 8 of this law, this law will not hinder human rights. And in other words, this law only deals with the case where individuals violate the law of Vietnam. It is in line with Article 19.3 of ICCPR. Cyber security law also does not hinder user of internet to, limit their rights, but also deals with the case where they misuse of the internet in order to defame the party or defame the government. U.S. and EU also have similar provision on defamation. So once again, let me confirm that the cybersecurity law of Vietnam does not hinder the freedom of expression and freedom of speech. Everyone are entitled to the freedom of expression and freedom of press. But let me confirm once again that this right is not an absolute right. Exercise of this right must be in line with the rights of others and also must be in line with the law. Decree 147/2024 of Vietnam regulate the use of internet, replacing the decree in 2013. Under this new decree, it required the social media user to provide the identity information, that is registration. It is necessary to satisfy practical requirement to reduce the misuse or abuse of the internet space to violate the law, for example, fraud, terrorism, or slander, or defame others, just to name a few. The purpose of such a requirement is also to ensure and safeguard legitimate rights of other people on the internet space, and also to develop healthy internet space, and also it encourage transnational businesses to work with Vietnamese authority in order to manage the social media platform, social media platform. Regarding to the question whether or not we will revise, law on freedom of expression, the government of Vietnam already enacted a resolution to revise the press law, which require the amendment of the press law to be in line with the current situation, and also to satisfy requirement of digitalization of the press, to make sure that the press will continue to promote their roles in the promotion of healthy internet environment in Vietnam. So in December this year, the draft amended law on press will be submitted and considered by the National Assembly. That's all for me. Thank you very much. And now I'd like to invite Ms. Chantiminga from Ministry of Religious and Ethnic Affairs to take a few questions from the committee. Distinguished member of the committee, regarding to a number of questions raised by the committee, there are two big religious group, Hoa Hao and Cao Dai. They encounter difficulty in registration. I would like to respond as follows. The state of Vietnam recognize Hoa Hao. They have been recognized the Buddhist, Hoa Hao. And for Cao Dai, a lot of their organization has been recognized and registered. So I can say that there's no difficulty for them in getting registration. For other, organization of these two groups, not yet been recognized or registered. If they make the request to the authority, the state authority will consider, and once they request, we will consider whether the application satisfy requirement provided under Article number 16 of the law on religion and belief, and also Article 18 of the same law. The right to freedom of belief and religion over the past few years has been effectively implemented, which safeguard the right of, a lot of different religion and organization. From 2018, since we start the implementation of this law, until 2024, we provide registration for collective religious gathering for more than 900, religious groups. So those are some achievements made over the past few years in order to ensure the freedom of religion and belief, and also regarding to the two religions, Cao Dai and Hoa Hao. That's all for me. Thank you very much. Allow me to provide some additional information regarding to the question raised by the committee member. In Vietnam, given the characteristic of our residential, there's no concept of indigenous people, and it is not used and recognized in Vietnam. So among the list of ethnic minority group of Vietnam, we only use the term ethnic minority or small ethnic minority. So ethnic minority of Vietnam, as I mentioned earlier, they are entitled to all the human rights and citizens' rights, and also certain priority provided by the law, according to our report, and also the assessment of international organization. The guarantee of the rights for ethnic minority in Vietnam has gained significant achievement due to the geographical attribute in Vietnam. Most of them live in mountainous area, so they still encounter certain difficulty in terms of infrastructure and getting access to the supporting service available for them. But thanks to the current policy of Vietnam, they are facilitated in order to get access to social supporting service to ensure their human rights and citizens' rights. Ms. Phương from Supreme People's Procuracy, and then Ms. Ha from Ministry of Public Safety. So, committee, regarding to arbitrary application of Article 74 and 107.3 of the Criminal Code. So, allow me to confirm once again that we never limit the right to get access to defense counsel for the defendant and detainee, and the only in case of national security violation, we will apply those Article 173.5 is only applied in limited cases, for example, cases related to national security crime. And as I mentioned earlier, only the Prosecutor General of the Supreme Procuracy will have the power to make the decision in such a case. So the committee also mentioned there are many cases of arbitrarily extension of detention, but we record no case of such a nature. So if the committee could provide the more detail about such a case, we are willing to provide response. So Ms. Ha from Ministry of Public Security, please. Regarding to one question regarding to tax evasion crime, not only Vietnam but all countries all over the world, they have regulation about tax evasion, and they introduce accordingly penalty to be applied. In the case of Vietnam, every citizen are equal before the law. Only those violate the law on tax, for example, the tax evasion will be considered by the authority, so it cannot be considered as a punitive measure against any activists like wrongly alleged by many other organizations. So they reserve the right to file complaint if they are not happy with the decision made by the court, for example.
Your Excellency, as I'd like to thank our delegation, and I give the floor to Your Excellency, Mr. Nguyen Thanh Tin, for your concluding remarks.
Thưa Ngài Chủ tịch, thưa các vị thành viên Ủy ban, thưa quý ông quý bà. Thay mặt đoàn Việt Nam, tôi trân trọng cảm ơn các thành viên Ủy ban về những trao đổi thẳng thắn và xây dựng trong 2 ngày làm việc vừa qua. Theo chương trình phiên họp, đoàn công tác của Việt Nam đã trao đổi, cung cấp thông tin đối với hầu hết các câu hỏi và bình luận của Ủy ban.
So, Mr. Chair and distinguished member of the Human Rights Committee, I would like to express our sincere appreciation to the member of the committee for the frank and constructive dialogue over the past 2 days. So, in line with the extent of Vietnamese delegation has engaged openly and sincerely and provide information in response to the question and comment of the committee. But due to time constraint, the delegation may not have been able to provide full and detailed response. And within the next 48 hours, we will clarify more questions from the committee. So, ladies and gentlemen, protection and promotion of human rights are both the objective and the result of a long and rigorous struggle by many generations of Vietnamese people. We recognize that human rights value are universal and global value, and the promotion and protection of human rights is an inevitable process in the development of all countries. However, each country will have its own mechanism for applying, different mechanism to protect human rights and citizen rights in line with their specific economic and social condition. So nearly over 40 years of comprehensive reform in Vietnam has shown that on policy and law in Vietnam are to better serve the people, and the happiness and satisfaction of the people are the ultimate goals of our law, our policy. So as an active and responsible member of the United Nations, Vietnam has continuously improved its legal system with a people-centered approach to ensure that people will be the subject and also the beneficiary of our policy. The country has implemented a lot of policy for women, children, and persons with disability and ethnic minority in order to ensure their rights. Vietnam remains steadfast in its part of building a democratic, equitable, and civilized society. And also, we are more and more proactive in international integration. Vietnam is determined to formulate and implement sustainable social policy based on human rights for the people, placing the people at the center of this process. We highly value the recommendation made by the members of the committee regarding to the need for Vietnam to further narrow the gap between policy, formulation, and implementation. Good law, also need to be effectively enforced and implemented to introduce a positive implication. So this is also the policy of Vietnamese government. Our effort to decentralize power and to shift from pre-approval to post-approval mechanism, and also eliminate intermediate level of administration to streamline the state apparatus. That is a strong, commitment of Vietnam in order to achieve those goals. So once again, allow me to express our sincere appreciation to the chair and also to the members of the committee for taking time to engage in this open and constructive dialogue. We also extend our heartfelt thanks to the Secretariat, the technical team, security team, interpretation team for their delegation and their professionalism throughout the past 2 days for this dialogue. On behalf of Vietnamese delegation, I would like to reaffirm the strong commitment of Vietnamese government in close cooperation with every relevant stakeholder in the process of implementation of ICCPR. Following the conclusion of the dialogue, we will promptly report back and submit a proposal to the Prime Minister for the adoption of a national action plan to effectively implement the recommendation of the committee. Thank you very much.
As we conclude this session, I wish to express my sincere gratitude to all those who have contributed to this dialogue. Over the past 2 days, our dialogue has addressed key aspects of implementation of international covenant on civil and political rights. We commend the State Party for its progress in several areas, such as ratification of 7 out of 9 core human rights treaties, the adoption of certain institutional safeguards to prevent discrimination, and efforts to address domestic violence, gender equality, and anti-corruption. At the same time, our discussions have highlighted a number of remaining concerns that require the State Party's attention, including severe restriction on fundamental freedoms, particularly freedom of expression, association, and peaceful assembly, a persistent lack of judicial independence and fair trial guarantees, as well as credible allegations of torture and ill treatment, the concerning continued application of death penalty, and persistent challenges for vulnerable groups, including women, children, LGBTI persons, and ethnic and religious minorities. At this point, I'd like to reiterate, as I emphasized in the beginning of the session, that no individuals or organization should face any form of intimidation or reprisals for cooperating with the committee. This safeguard is essential to ensuring the effective implementation of the covenant, and we trust that state party will uphold this obligation. The committee notes that during the dialogue, some questions were not fully and comprehensively addressed by delegation. As per the committee's standard procedure, the delegation may submit a brief written response to any outstanding questions within 2 working days. This means it should reach the Human Rights Committee Secretariat by Thursday, 10 July, 1 p.m. Such additional information will contribute to a more comprehensive assessment and will be reflected in our concluding observations. On behalf of the Human Rights Committee, I wish to thank you, Excellency Mr. Nguyen Thanh Tin, and the entire delegation for constructive dialogue, and I wish you a safe return home. Finally, I'd like to thank all committee members for their thoughtful interventions and to express my sincere appreciation to Secretariat, interpreters, and technical staff for their essential support throughout this session. Thank you all once again for your cooperation and commitment. The meeting is adjourned.
Thank you so much.
you.